Lydia, and Lydia is asking, my sister and I own a property jointly. She lives in it and she wants me to pay half taxes and insurance. What is my recourse?
So remember, first of all, the question of the relationship between you and your sister, right, it comes to play here. So what is the understanding on how the property is actually going to be utilized? So I need to step back and forget the family dynamics, forget all of that, and start looking at this in the most rational way possible, right? And now this is an approach that comes from structuring experience. So we're chatting about how the property is actually being held. Is it jointly owned by the two of you in your personal capacity? Is it held maybe whatever in a trust in a company, and you guys are directors? Because each one of these things would play a different role at the end of the day. The other thing that's important to emphasize before we answer the question is there's a very big difference between ownership and your rights that are encompassed by ownership. So remember, ownership is like, like a big baskets are not full basket, right? A big basket, and inside this basket there's a whole range of different items and rights and duties and obligations, a whole range of stuff inside, right? So certain of these rights can be given away, they can be ceded. So just because you're owner of the property doesn't necessarily mean that you can do whatever you want with the property. So as an example, there's certain restrictions that the municipality wouldn't let you, for example, run a business from certain properties. That right is a right that basically you as owner cannot exercise without the municipal consent. Tenants are another typical example of this. The tenant takes over that right of occupation. So provided that lease agreement is still in place, the tenant actually has a stronger right of occupation than you do, right? So that's a conversation that we need to have. Occupation and ownership, these are two very different rights, and how the property is actually held and what the relationship is between the parties. So let's now quickly jump into the question. Are you obligated to pay the rates, the taxes and insurance? Now remember, as co-owner, right, typically whoever, so the municipality doesn't care who pays it out of which account. At the end of the day, it's co-ownership. So the expectation is that the municipality be paid its property rates. So as against the municipality, you can't say, no, I don't live on the property. That's got absolutely nothing to do with the municipality. Insurance companies, typically the same thing. The insurance companies insure the owner of the property and the property itself, naturally. So the insurance company doesn't care from which account it comes in. So if one person's only paying half and trying to blame the other one and saying that the other one needs to pay the other half, that's not going to help. The insurance company is going to stop the policy. The municipality is probably going to disconnect the power or the services. And I mean, it doesn't say anything about a mortgage bond, but I mean, if you've got a debt over this property, the bank's going to foreclose and the bank's going to go after you and your sister. So the liability to pay these amounts typically sits in the hands of the owners. Now, if you're joint owners in your personal names, then it would normally be jointly and severally liable. That means that they can collect from either one of you. Doesn't matter. They'll collect from the one that they feel is the strongest person to collect from, and they'll go after that person. If it's sitting in a company or a trust, for example, which is how we typically advise property investors to trade, in that instance, it would be the trust that's responsible for payment. So there the answer starts looking a little bit differently. Are you personally liable? No. The company is, or the trust is. You might be personally liable, for example, if you signed a surety on behalf of the trust in favor of the bank or whatever the case is. But it's the company and the trust. Now, what is the relationship? And this is why I pointed out ownership versus occupation are two very different rights. Your sister wearing the occupier hat is different from your sister wearing the owner hat. So what is the relationship between these two people wearing these two different hats? What have the owners entitled this person to do? Because certainly there has to be a payment for the enjoyment of the property or some sort of compensation. So at the very least, if the trust or company of the joint owners aren't making a profit from the rental, at the very least, the person occupying the property, in my opinion, this is just like a more personal opinion than legal opinion, should at the very least cover the expenses associated with the property so that the owners don't need to carry that themselves. So yeah, that's the legal advice mixed with a bit of practical advice. I hope that kind of makes sense. Recourse, what's your recourse? Unfortunately, unless we know what the arrangement or agreement is between you and your sister, the typical recourse would be each person would be liable 50-50. You could potentially, and I mean, I suppose this is arguable, but you could potentially, as a co-owner, go after and say that she's enjoying occupation of the property, and that also carries a value to it. So now there's a value of occupation that she should owe herself and you, right? And from this value, then the expenses should be split, and whatever amount comes in should then be split between the two of you. So there is recourse, I would think, but yeah, I mean, we would have to look as to what the arrangement was, what the agreement is, and yeah, that's it.
Yeah, that's what I'm. As you were talking, I actually thought it sounds like one of those situations where the reason for the ownership and the joint ownership between the sisters, it could very well be an inheritance. And if that is the case, and the will doesn't deal with who can occupy or whatever, then it falls back to exactly what you said, Bruno. But I mean, it always falls back on what you said. But I wonder if it does come from a will. I just want to throw in my ear just picked that up, and I thought maybe we should just mention that if it was in fact on the back of a will, just make very sure that the will doesn't specifically deal with something around occupation. For instance, if the one sister received cash and then co-ownership, and the other one co-ownership and the right of occupation, or something like that. So just be careful if it is on the back of a will, because we've seen funny things.
Yeah, no, I agree with you.